Hello, Karen.
Good morning, Matt. Hello, how are you?
Good. Can you see me?
I can. Ta-da.
Okay. All right.
So we're just gonna sit tight and be quiet for just a second, and then we'll start spot on at 8 o'clock.
Okay.
All right, well, we are at the 8 o'clock hour, almost on the dot. And I would like to say good morning and welcome to each of you that have chosen to join us this morning. You're joining us for the fourth of a series of 7 web seminars presented in partnership with the Dakota County CDA and Chamber Partners. Today's topic is employment legal considerations and management. Just a few housekeeping items for each of you. All participants are muted. Please submit your questions using the Q&A feature. The recording of the seminars will be hosted on the partner websites. Also, we are truly glad you are here. These are unprecedented times, and the goals of these web seminars is really to provide valuable information for small businesses as you consider what it's going to take to begin to bring your business moving it forward. My name is Karen Schaffhausen. I'm a business advisor for Open to Business. Today, to discuss our topic is Matt Scott. With that, Matt, I'm going to turn it over to you. Thank you again for joining us, and I'll let you take it from here.
Thank you, Karen. My name is Matthew Scott. I'm an attorney with Doherty, Melinda, Sofa, Stilson, Bauer, and Apple Valley. We have 16 attorneys. I'm a business litigation attorney, but I practice in employment law as well. And I just want to thank the chambers, all the different chambers that are collaborating with this, as well as Karen, bringing it all together. It's really, I think, an example of how small businesses in our community all kind of collaborate to teach each other and learn from each other. So we're going to dive right in. There's a lot to cover. I'm going to move to the next slide. So we have a lot of different laws, and I just want to summarize kind of the things we're going to do. We're going to talk about the changing laws. We're going to talk about the Families First Coronavirus Response Act. We're going to talk about unemployment insurance, protecting your Paycheck Protection Program forgiveness on the back end of these loans. We're talking about coronavirus in the workplace, and also some wage and hour considerations for employees working from home. And then probably the question some of you are wondering about, can I be sued? And so we'll get to that as well. You can go to the next slide. Now there are changing laws. Laws have changed in the last month. The existing laws have even been modified and are now operating in a different way. So we have the Paycheck Protection Program. There have already been a lot of discussions around that in past webinars, and I'd encourage you to go back and take a look at those. This is a very timely topic. This is something that's happening daily. The banks are really dealing with a lot of applications. Wells Fargo even closed its applications down over the weekend because of some issues it had with prior governmental contact. But the Families First Coronavirus Response Act is another piece of legislation that is really important to you and to your business. It's most important because it's important to your employees, and there's just a lot to digest in these different laws. Unemployment insurance has also changed, and it's also been supplemented by federal legislation in the CARES Act. Next slide. So the Families First Coronavirus Response Act has a number of different components. It has laws within the law. And what you need to know as an employer is that this matters to you because your employees matter to you. We want to see them do well. We want to see them survive this and come out on the other side able to come back to work. It's also important to ensure that your employees are staying home when they should be staying home. And if they have to stay home because you're a non-essential business in a non-critical sector under the governor's order, this provides a backstop for them, at least for 2 weeks, and in some cases up to 12 weeks if they're caring for children or a family member who is ill. So really there are two components of this. There's the paid sick leave for the employee. That provides up to $511 a day for really 10 days, or the equivalent of a 2-week work week. And it's $5,110 as a maximum if you're staying home because of something that you are dealing with. If you're dealing with a family member's illness for the first 2 weeks, you get 2/3 of your pay up to a maximum of $200, and that's capped at $2,000 for that 2-week period. There's also an additional 10 weeks for parents who have childcare that's closed or schools that are closed and they need to be home with kids because of that. What's important to note about this is that you don't get this benefit if you just choose to stay home from work, if your office is open and your business is in a critical sector. So if an employee says, I just don't feel comfortable coming to work, that's not enough. They have to fall within these other criteria. You can go to the next slide. So the important thing about the kind of on the Families First Coronavirus Response Act, a few points. Employees who take this leave are entitled to continue coverage under their employer's group health plan on the same terms. So you can't change things after the employees take this leave. And some of it's going to be pretty long. I mean, you're going to have employees that are off for potentially 12 weeks, potentially even a little bit longer than that if they're taking their own and then someone else's leave for someone else being ill. Employees must be restored to their same title and position as they were before they started the leave. Employers are required to retain written documentation for 4 years. That's it, whether you're granted the leave or whether you're denied the leave. And it's important to note too that the amount of the pay, whether it's 100% or 2/3, depending on their situation, is going to be based on the average earnings for part-time employees. And also overtime, if it's anticipated, needs to be included in that payout. Every dollar of this, and this is where the accountants are going to play a role, every dollar of the required paid leave, plus the cost of the health insurance premiums for the leave, or during the leave, will be 100% covered by a tax credit. So this is something that is essentially should be free or close to free for the employer. But there's an interesting caveat to this, and some people might say, well, I saw that there was an exemption for employers that were 50 or fewer, and I'm under 50, and I want to see if I can claim this exemption. There has to be hardship of some kind. And when I look at this, a law like this, where there's a tax credit, it's going to be harder to show that there's hardship if you're essentially getting a tax credit, or refundable tax credit, for the amount of money that you're paying your employees for this type of leave. Next slide. There are notice requirements that go along with this. I know a lot of you have posters in your break rooms. This is a new poster. You need to get it up if it's not up already. It's available on the Department of Labor's website. It needs to be posted in the workplace, and then if you're a larger employer, 50 or more, you can email it or direct mail to employees. But again, the Department of Labor website is a great resource, and it includes this poster. It's available there. Next slide. So one of the components of employment and in caring for your employees in this time is unemployment insurance. And of course, the Paycheck Protection Program wants you to keep your employees employed for those 8 weeks, paying them with essentially a forgivable loan. But if that's not possible, and if there are some strategies where maybe unemployment is going to play a role as well as the Paycheck Protection Program, the Executive Order 2005 from Governor Walz included a number of provisions that change how the unemployment insurance program works in Minnesota temporarily. So it suspended strict compliance with unemployment insurance laws. It sped up first payments. It expanded the categories of qualifying conditions. So it includes things like you're sick, or you're not sick, but you're immunocompromised, or you can't work because of an outbreak at work, or you can't find care for your kids. If you're immunocompromised, you're going to need to probably demonstrate that with a note from your doctor, but that's an unusual categorization for an employee to say, you know, I have asthma, or I have a heart condition, or have something that would cause me to be more likely to be affected by coronavirus than other employees. And under those circumstances, those employees could even qualify for unemployment insurance. It's important to note too that the payments at this point for coronavirus type leave or unemployment insurance are not going to affect the employer's premiums as they typically would if you just terminated an employee's employment. So that's a benefit to employers. There's also no 5-week limitation for business owners, so that's taken away. There's also some additional components where the CARES Act has provisions in it at the federal level that are going to supplement some of the state unemployment insurance benefits. So the federal pandemic emergency unemployment compensation is 13 weeks of extended benefits. This is something that the state is still working through. They don't have guidance quite yet. So some of these things are so new that even at the state level, they're not sure what to do under these programs, and they're waiting for further guidance from the federal government. There's also the federal pandemic unemployment assistance, which is very unique in that it allows people who would not otherwise be entitled to unemployment insurance to seek it. So that would include self-employed people, independent contractors, clergy, and farmers. And the state recommends that you apply if you fit into those categories, but they can't pay the benefits yet because they're still waiting for further guidance from the federal government. Next slide. So there was a very recent executive order on Monday that streamlined some additional things, adding to the prior executive order from March. So employers must notify separated employees, that means employees who you're not allowing to come to work, that they can apply for unemployment benefits. There's no poster for this. You just need to notify them that they would be entitled to, or that they can seek unemployment benefits. And DEED is no longer requiring a delay in benefits for people who are using some vacation or PTO or sick pay to sort of cover a time after they are formally separated from employment. So remember, and I would say that I deal a fair amount with unemployment insurance benefits and people who are on both sides of the equation and the appeals that go along with that. This is designed to protect people who are unemployed through no fault of their own. So if you quit your job, you don't qualify. Also, if you punch your boss in the nose and get fired, that's not going to qualify. There's disqualification for gross employment misconduct and employment misconduct. So this discussion all really focuses on COVID-19 and some of the additional protections that are provided, but there's still this underlying system in place that is going to continue to operate with some changes and modifications as discussed. Next slide. So you also have the CARES Act, which supplements state unemployment benefits. So you have what we just described as the state level benefits, but now you have the CARES Act adding $600 per week for employees. And that is going to translate into some additional dollars. For people who are curious, can an employee survive on what they're going to be receiving in unemployment insurance? A lot of employers are concerned about their employees and they care about this stuff. But these calculations on this page just generally show $740 a week is the max you can get under state law. And that works out to half of your salary. So basically you receive about half of what your normal is. And the maximum of that half can be $740 per week. If you look at it, that works out to about a $76,000 or $77,000 salary. And you get that for 26 weeks. And the federal extension adds 13 weeks to that. So it's quite a long time that you can receive benefits under this combination of laws. The CARES Act adds $600 per week. So really, you could receive 100% of an equivalent salary to about $70,000. So that's a pretty significant amount of money. And I only note that because there are times when employers, go to the next slide, employers are going to have conflicting decisions to make. Do you keep your employees and do you pay them for 8 weeks using the Paycheck Protection Program money, which is essentially a free salary or free wages? Or do you lay employees off, lose the Paycheck Protection forgiveness, but the employees then have the Families First Coronavirus Response Act, where there are tax credits for employers, or they have the unemployment insurance benefits with no tax penalty to employers. So there's some real hard decisions that employers need to make, and there's some dates that really matter to your decision making. And you need to take a close look at the forgiveness elements of the Paycheck Protection Program, and in particular, when you need to have an employee hired back, and when the cutoff is for making some of these decisions to keep employees home. April 26th is an important date, and June 30 is an important date under the Paycheck Protection Program. Go to the next slide. So to protect your forgiveness under the Paycheck Protection Program, everybody wants a really big loan, but everybody also wants that loan 100% forgiven because we're not really interested in borrowing money we have to pay back in such a difficult time. And so how do you protect the forgiveness under the Paycheck Protection Program? Well, what you need to do is you need to use the proceeds from your loan to pay employees during the 8 weeks after getting the loan. So that's a pretty basic one. I think a lot of people know that. And you should not use more than 25% of the loan funds for non-payroll expenses. So don't use more than 25% for rent or utilities or a mortgage payment, or you'll jeopardize the forgiveness potentially. You do need to bring employees back by June 30 of this year for changes made between February 15 and April 26. So if you've let employees go and the employees are not hired back by June 30, and you've made those changes between February 15 and April 26, you need to get the employees back on the payroll by June 30 in order to protect your forgiveness. And do not decrease the employee headcount of full-time employees. You're going to have a drop off in the forgiveness if you do that. And then do not increase salaries by more than 25, or decrease salaries by more than 25% for any employee who made less than $100,000. So for those of you making more than 100,000, you might be out of luck. The next slide. I wanted to address coronavirus in the workplace. Obviously, social distancing is an obvious thing you need to be doing. But in this environment, over-communicate with employees. Employees are more separated. They're working from home. They're remote. They're not seeing their coworkers on a regular basis. They need to hear from employers. They need to know that employers are taking care of them and taking care of the business, because everybody cares about whether they're going to have a job when this is all over. And it will be over at some point here. Succession planning. Review your plan. Make sure that if some key person is no longer available for the next 2 weeks and is not able to work, that person is not going to kill your business in the meantime. Test employees if you have concerns. The EEOC, which is the federal level, allows you to get a thermometer reading. They prefer non-contact thermometers. Given the potential direct threat to others who could be exposed to the virus. So this is not a normal thing. It's not usual. Got a link to the flu page and the guidance from the EEOC. They've updated the flu pandemic to include COVID-19. So it covers more than just the flu now. And you'd be kind of surprised at the level of invasive testing you can do as an employer if you have real concerns about whether someone should be at work. You can ask about symptoms. Do you have a fever? Are you experiencing shortness of breath? And if the employee says they are, then you send the employee home. You need to keep the records confidential. You need to keep test results confidential. And you can't tell everyone, hey, John had or has coronavirus, but what you should be doing is if John had contact with employees at the office, you should warn those employees that they were exposed. Next slide. There's a lot of confusion around HIPAA and HIPAA compliance, but most of you are not medical providers, healthcare providers, so it really doesn't apply to you. Employers are governed by the Americans with Disabilities Act. Employers can ask employees if they have tested positive for coronavirus. If someone is infected, they should isolate at home. They shouldn't come back. There are protections for them under the Family First Coronavirus Response Act. The same is true if they have a sick family member at home. And don't punish them for this in any way. Don't retaliate for this kind of behavior. And when they come back, put them in the same position they were in before. And respond to the infection. If there's someone in the office who's infected, their work area should be disinfected, cleaned, and should not be occupied for 24 hours or longer, and just follow the CDC guidance on this. And now is not the time to demand a doctor's note and demand full documentation. If someone has a cough, if someone is not feeling well, that should be enough for you to be able to send them home and allow them to go home. There will be time, and there are times, days or a few days later when documentation can be obtained. But this is a difficult time for healthcare providers, and some of these doctor's notes may not be readily available to employees. And with the daily changes in this virus, you don't want to hold them to a strict standard. Next slide. There are employees that are working from home that are hourly, and this should be a concern for you more so than salaried employees. Hourly employees are entitled to breaks, they're entitled to lunch, and you need to keep track of their hours while they're out of the office. This is important not just for keeping track and making sure they take breaks, but also making sure they don't work overtime. Employees are very dedicated to their employment and to their employers, and what we don't want is people spending more than their usual workday at home, but not keeping track of it. That's a bad scenario going forward, and could have repercussions in terms of lawsuits for large employers if they don't do a good job of keeping these records down. Hazard pay, if you pay hazard pay, it may have implications for overtime. So if you increase someone's rate of pay, make sure that you're accurately reflecting that it's hazard pay and not part of a regular wage increase for the employee. If you're reducing an hourly employee's wages, for large employers, it's $10 an hour. That's the Minnesota minimum wage as of January 1. So make sure you don't reduce their wages below the minimum wage. And if you have payroll questions, talk to your payroll provider. They're a great resource in this context around some of these wage and hour questions. Next slide. Could I be sued? I know in any injury lawsuit like this, you have liability questions and you have damages questions. COVID-19 is very difficult to track because it is sometimes it's not showing itself until days later. And so it's difficult for an employee to show or prove that they contracted the virus while they were at work. The damages are, the reality is that some people do die. They have significant damages, or their families do, but most people recover. The bigger question is, are you being reasonable? OSHA says that each employer has to furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. There is some risk that if an employee is put in a compromised position and reasonable safeguards are not taken to protect the employee from COVID-19 or contact like that, that an employer could face some risk. Walmart has already been sued after one of its employees contracted COVID-19 and died. And so the lawsuits will come, but exercise good judgment. And if you think about it, if you put the safety and health of your employees and your customers first, and you work backwards from there, you come to a lot of good measures and protections that can be used and will be very effective in combating any argument in the future that your company should be held liable if someone contracts this virus. And with that, I think we're done, and we'll open it up for questions.
Matthew, thank you so much. We do have a few questions. I'm going to pull them up here. So what steps may an employer take when an employee defiantly ignores company directions to stay in place and not travel to known COVID hotspots?
I think like any, I'm not sure about the context for that, but like anything, if you have concerns that the employee is disregarding social distancing, is traveling different places, that's a difficult question, but it's probably one where that employee should be isolated at the office, isolated at work, and also, there may be circumstances where if they're exhibiting, they could be tested on a regular basis. So some of the testing that I referred to, most employees are probably not going to need that, but some employees might need to be asked these hard questions. Where have you traveled? What have you done? I need to take your temperature. Keeping track and monitoring those people, it's kind of an unusual circumstance where somebody doesn't care about their own health. But use good judgment, and if the employee needs to be sent home, potentially want to do the best thing for your employees, your other employees, and so I guess there are potential risks of sending them home and keeping them at work, and if you are more concerned about their health and the health of your employees, sending them home may be something that you could think about. I'd probably want to know more about the situation before somebody relies on that comment, but that's an interesting question.
It is. So one of the questions that we've been getting and fielding on our end is, I've got employees that are afraid to come in and work. What do I do about them?
I think what you do with the employee who is afraid to come into work, you have options to allow them to stay at home. You have, unpaid leave, but a lot of us need our employees in order to continue to make money during this crisis and to continue to function. What I think, the best strategy in those circumstances are, you can pay hazard pay if you think the employee is exposed to more. a lot of these grocery stores and a lot of different employers are using hazard pay as an incentive to employees who are very reluctant to leave their homes. You can also really make it clear to employees through communication what steps you're taking to clean, to disinfect, and to make sure that the workplace is as safe as it possibly can be.
So, can you do us a favor and kind of take that one step further? Because you've got both an employee who could considerably be vulnerable, but maybe not have what a doctor would consider. So it's like, my personal opinion is this is what I think I am, so I think I'm vulnerable. And you've got an employer who's a critical employer saying, we need you to work so you can use hazard pay. Does it come to a point, Matthew, in your opinion, where an employer needs to kind of use, and I really appreciated that you mentioned this, that kind of that underlying system of how you manage employees through the process, regardless of this pandemic?
So what was the specific question?
So take the same thing that you just shared and talk about, take it one step further and say an employee isn't willing to come into work, hazard pay doesn't work. Now you've got an employer that's concerned about maintaining, if they've applied for and received funding for PPP. Now this employee may not come back to work for whatever reason. So it's kind of a balance of two of your slides. What is an employer going to do, and how do they make hard choices based on a system that's already in place for an employee that isn't willing to work, and the employee's right to make a choice on their own?
It really, in some cases, I think this PPE program is still developing, and you need to look at the forgiveness guidance as it continues to come out.
Right.
Some employees might be able to be paid to sit at home for 8 weeks. I think the program is designed to make sure that people still have income coming in. Now, they can also be given leave, and that leave is going to presume to be involuntary under the governor's order, the 2005 order. But that involuntary leave would put them in a position where they can then seek a note from a doctor and get that proof, to get the proof they need that they're immunocompromised. If they are not immunocompromised, if they just don't feel comfortable coming to work and they choose not to come to work, there's going to be there are consequences for that. There's not a situation where you could just choose, hey, I don't want to come to work, and I'm not going to go to work. If you're in a position where you need to tell an employee, hey, I need you to come to work, and if you don't come to work and you're not sick, you're in a critical sector, discipline still occurs in this context, and failure to show up for work is still something that you can discipline an employee for. But it's a sensitive area, and so you need to exercise good judgment and don't leap to the termination or the separation from employment as the first thing you choose in this discussion.
Well, on that note, we are at the 8:30 mark. And so, Matthew, I just want to say thank you again for sharing your time and your information with us. It has been exceedingly enlightening and very valuable. And I'm super grateful that you're kind enough to share your time and talents with us today. Just a quick reminder, these webinars are provided in partnership with Dakota County CDA and Chambers. We've got 3 more up. We're going to switch gears from some technical business stuff this Friday, talking about how businesses that have historically been retail move online and continue to engage their customers, even the most difficult. We're going to switch back to more technical conversation on April 13th, next Monday, talking about some of the key things even that Matthew has identified from a tax perspective on Monday, and then again a little bit more on the marketing and sales on the April 15th. About Open to Business, we are a nonprofit that's contracted by the 7 metro counties to provide free business consulting and gap financing. The recording of the seminar will be shared with the county partners and posted on their websites. Thank you all for joining us today. We hope you have a good day. Take care.